Speaker series. We're delighted today to have Professor George Foster from Lewis and Clark Law School in Portland, Oregon. Professor Foster's been doing a lot of work in the area of international investment law, both in practice and now as an academic. And one of the particular features that he looks at is ways of using international investment law to offer protection to different communities, including Indigenous peoples. And he's giving us a talk today in related areas, and I think we have some very interesting discussion to look forward to, and I'd ask you just to join me in welcoming George Foster.
Well, thank you all very much. It's really a great pleasure to be here. Usually with my students, the problem I have is that they all want to sit in the very back. For some reason, you guys all want to sit on the left side of the room. I don't know what it is, but that's great. So yes, I want to express what a pleasure it is to be here and how grateful I am to the faculty for inviting me, and in particular to Professor Newman for arranging this. This is I've had a very warm welcome so far, and it's great to be here. So the subject of my talk today is foreign investment, the relative power of the various actors involved in or affected by foreign investment, and the impact that investment treaties have or could have on those power dynamics. So I thought that to begin with, it would be helpful to provide a little bit of background on investment treaties for those of you who may not have studied them in any depth. So investment treaties are international agreements between countries that the governments enter into in an effort to try to promote foreign investments, and they do so by offering various benefits and protections to investors. So this would be investors coming from one treaty party to the territory of the other. There would be these benefits offered by the country that is hosting the investment, the host state. And these protections can come in various forms. There are substantive and procedural protections. So the substantive protections typically would involve an undertaking by the host state to the investor from the other parties to treat their investments fairly and equitably, not to discriminate against them in favor of host state nationals or third country nationals, to respect obligations into which the government may have entered, so that could be contractual obligations with the investor, and also not to expropriate the investments without adequate compensation. And these, and then in terms of procedural protections, the principal one is the private right of action, an opportunity on the part of the investor to bring a claim directly against the host state in an arbitration forum, a neutral international arbitration forum, alleging that the investor's rights under the treaty and under international law have been violated. So it's an opportunity to try to enforce those substantive protections. And these treaties come in various forms. So the vast majority of them are bilateral, and there are around 3,000 of them at this point between individual pairings of countries. Canada has many of them. And then there are also some that are multilateral, a good example being NAFTA. I'm sure you're all familiar with NAFTA. It has, even though it's more broadly a trade agreement, it has embedded within it essentially an investment treaty or an investment chapter. And there are all kinds of reasons that governments enter into these treaties, that is to say why they want to promote investment. There are benefits that can come from foreign investment in terms of when you have investors coming in, investing in a particular project. This typically generates governmental revenues, employment opportunities, and it can also, if there may be technology or capital that the investor's bringing in that domestic actors wouldn't be able to bring to bear, and that can expand the development of a particular resource that the government may want to develop. Excuse me. But there are also concerns about foreign investment in the sense that of the impacts that they can have on the environment or on local communities, what I would refer to as local stakeholders, meaning people who have some sort of stake in the investment in the sense that they're potentially impacted by the investment, whether we're talking about Indigenous peoples or other individuals who live near a development project, or workers, somebody who might work for the investment. To give you a couple of examples, in the construction or infrastructure industries. Let's say, for example, you have a hydroelectric dam that's being built. This could have, when the dam inundates a particular area, it may be displacing indigenous peoples who lived in that area or other communities. Obviously, it can have an effect on fish populations and so on. Another closer to home, an example of infrastructure. I'm sure you've all heard about the Northern Gateway pipeline that Enbridge is seeking to build between Alberta and Kitimat in British Columbia, and there have been concerns about potential oil spills and protests by First Nations in the area that concerned about the impact that could have, those pipelines could have. In terms of natural resource extraction, that's another area that often has significant impacts on the environment and local communities. Just to give you a couple of examples within the natural resource area. Now, I could give you examples from all over the world. I've just sort of picked a couple that I think are that you may be familiar with and that are sort of high profile. So in Nigeria, there's been, over the last couple of decades, or several decades, there's been a major effort on the part of the government to develop the oil reserves in the Niger Delta. The Niger Delta is predominantly, the inhabitants in that area are tribal peoples who live a traditional way of life, largely been dependent on subsistence agriculture and fishing, and there's been some massive impacts on them, many oil spills, there have been fires and constant flaring of natural gas from the wells that have impacted the air quality, and the reports I've seen indicate that the native people in that area have been largely unsettled in their traditional pursuits. It's obviously very difficult to fish when there's an oil slick and so on. And so we've also then seen community resistance to the operations among the Ogoni and other peoples that live in that area who've essentially rebelled, tried to resist the development, and then we've had a crackdown by governmental forces, which was allegedly aided and abetted by Shell, the principal company operating there, and then there was allegations that they supplied weapons and so on to the government, which engaged in very brutal suppression and extrajudicial killings of activists and so on. So then, closer to home, we have the oil sands in Alberta. I understand that Saskatchewan has some oil sands as well, although there hasn't been much in the way of development. So I don't have to belabor it. I'm sure you're all familiar with the concerns about the impacts of the oil sands in terms of obviously the actual mining that takes place causes substantial disruption of the habitat in that area. When the oil is separated from the sands, the waste products or tailings are dumped in large open air tailings ponds, such as this on the right here, which there's concerns that this, because they're unlined, that there can be carcinogenic chemicals that can leak into the groundwater and make its way into the Athabasca or Peace Rivers. And then there have been reports of serious adverse impacts on First Nations in the area in terms of high rates of cancer in the Fort McKay area and elsewhere, and also fish that have been traditionally fished having tumors and other side effects, and impossible to carry on hunting of moose and other animals in pursuit of the treaty rights that were retained by these different First Nations. Now, of course, the oil development and the oil sands is by no means exclusively carried out by foreign companies. There's many domestic companies involved as well, but I think there's no doubt that the scale and the speed of the development has been greater than would have been possible through domestic investment alone, and most of the world's major oil companies have invested in one form or another in the oil sands. So in part because of these risks associated with foreign investment for the environment and local communities, there have been some widespread criticisms of investment treaties in recent years. After all, the purpose of these treaties is to promote foreign investment. In terms of the criticism is that they these treaties can facilitate misconduct by investors by tying the hands of the host state. Some people even say that they essentially they allow an investor to hold the host state hostage by the threat of a treaty claim, that if the host state regulates the investor in some way, impose any kind of burden on the investor, that the investor might bring a claim against the host state, and so the host state would thereby be discouraged from regulating, and this may be in part responsible for, or at least could in the future be responsible for human rights violations. And it's also sometimes said that investment treaties make investors more powerful effectively than host states, that there's this power disparity in favor of investors against host states. But at the same time, we have new treaties being concluded all the time. Canada has a very active treaty program, as does the United States and many other countries. Just to give you an example, there are serious talks underway about expanding NAFTA across the Pacific Ocean. So essentially taking NAFTA and enlarging it to throughout the Pacific Rim, countries in South America as well as Southeast Asia. So there's, this is very much a controversial issue, and it's going to impact, as the scope of these treaties expands, it could impact, have all the more impacts to the extent that there are any. So the thesis in my paper and what I'll be arguing today basically is I'm sympathetic very much toward these concerns about investment treaties, and I would certainly concede that there may, especially the older generation treaties, may not strike an optimal balance in terms of the relations between investors and host states, and may not give host states quite as much regulatory leeway as they should have. But in general, I think that some of the criticisms overstate the impact of investment treaties and the impact on host state regulatory authority. And that in general, these treaties strike, I think, a fairly decent balance in terms of between these, but when we're talking about investors and states. Now, the real problem from my perspective in terms of the impacts on local communities or the environment is not so much that treaties restrain host states from being able to regulate, but that there's not that inclination oftentimes, that the host state actually doesn't want to regulate the investor's activity, and that they're actually have a financial incentive to allow the investment to be carried out the way it is, and that to the extent that there's so that is to say the host state may be willing to turn a blind eye while human rights violations occur, or even commit violations in their own right. And to the extent there's a power asymmetry that's a particular concern from a human rights standpoint, it's between local stakeholders on the one hand, and investors and an effective alliance with the host state on the other. And that's to the extent we're concerned about protecting human rights and talking about how can we reform international investment law to try to do that, we should be targeting that asymmetry. Whereas the calls of critics typically say, well, if we're going to reform investment treaties, we need to expand host state regulatory authority and shrink investor rights. I'm concerned about that because I think investors have legitimate reasons to want these treaties and the protections that they provide, and I think host states actually have considerable leeway. The real focus, as far as I'm concerned, or at least a focus, should be on trying to establish some sort of mechanism whereby local stakeholders would be able to assert their rights under international law or under human rights law without having to, against investors directly, without having to rely on their government to do so on their behalf, because that's obviously not working. So what I have in mind is to first talk about the power dynamics between these various actors, okay, starting with the dynamics between investors and states and the impact that investment treaties have on those, and then contrasting that with the dynamics between investors and local stakeholders and the lack of an impact that investment treaties have there. What critics of investment treaties argue is that investors, oftentimes multinational companies, they have very strong bargaining power versus the government, and they may essentially, in terms of who's wearing the pants as between the host state and the investor, so to speak, it's the investor, that they're really able to be the dominant party in this relationship. Um, and I think that is certainly true, at least at the initial stage of a relationship when an investor is contemplating investment. The host state may be very keen to attract this investment, but we also have to realize that the bargaining dynamics can shift over time. Once the investor has come and committed its capital, the project is already underway, the investor loses some of that bargaining power, and conversely, the host state becomes relatively more powerful. And sometimes the host states, after all, they're sovereigns. They have the opportunity, if they decide to regulate. They have a monopoly over the legitimate use of force. And what we've seen is certainly in my own, I practiced for a number of years in international investment law, representing both governments and states. And I certainly saw many instances in which I had clients who were investors where the government did not hesitate to take action if they felt it was in their interest against the investor, sometimes even expelling them from the country. And of course, no matter how much money a multinational has, it's no match for police forces or military forces. So for example, recently in Bolivia and Venezuela, you had these expropriations of oil companies, and there wasn't much the investors could do about that. And this is actually the original purpose of investment treaties. This is why investment treaties were created, was to address this perceived power asymmetry, to give investors some sort of recourse in the event that their rights were infringed by a host state, and to give them the opportunity to go before a neutral international tribunal without having to rely on host state courts, and to be able to get damages, let's say for the value of their investment if their investment was expropriated. I think investment treaties certainly do that. They've been, a number of investors have successfully brought claims. But I think what the critics of investment treaties say, they go too far in their effort to address this potential asymmetry. They give investors all these rights and protections, but they don't impose any obligations on them. And this, the concern is that this results in sort of tipping the scale too far in the other direction. But I think what I certainly agree that investors should have obligations imposed on them by these treaties, as we'll see when I get later in my talk here. But I think in terms of the relations between the investors and the states, I think we need to be careful not to exaggerate the extent to which the host state is limited or impeded in regulating. What we have to emphasize, what I'd like to emphasize, is that investors have other sources of obligations. Even though treaties don't impose obligations on them, there are other sources of obligations which they have, which the host state is perfectly free to enforce should they be minded to do so. The problem is, as I've said, they often aren't inclined to do so. And were they to enforce these obligations, this would not normally be a violation of an investment treaty. Now, in terms of what obligations am I talking about? So there may be a contract that the investors sign with the state that imposes obligations on the investor. Under domestic law, there may be environmental laws, restrictions on pollution, for example. There may be labor laws protecting workers, all sorts of laws that may exist on the books, tort laws, nuisance laws, and if the host state were to decide, as they sometimes do, that they want to enforce these laws, that wouldn't normally violate the investment treaty. And why is that? Well, at least under the better reason cases, and I think certainly the weight of authority, the newer cases, not necessarily the very early cases, but the newer cases over the last several years, tribunals have very widely recognized the doctrine of the police powers, that governments under international law have a right to regulate for the public interest. And if they enact laws that are generally applicable, that are non-discriminatory and enacted in good faith for a public purpose, that's within their power. And certainly if the investor violates these laws, then imposing a sanction, a proportionate sanction, would be consistent and would be their entitlement under international law, would not give rise to liability under an investment treaty. And that would even go to enacting new laws after the investor's in place, again, so long as they meet the criteria that I've mentioned. Now, some tribunals have had a caveat where they've said, well, the result may be different if the host state explicitly promised the investor in some way, such as in a stabilization agreement, that they wouldn't change the law in that particular way. And so that could be some concern. There might be some risk that the host state would make such an assurance. But I think a very good argument can be made that even in that situation, the host state, while they may be obliged to respect certain obligations, if that obligation is inconsistent with the host state's international obligations that are human rights law or otherwise, then the host state would be free to abrogate that. Now, one of the core elements of investment treaties is this notion of legitimate expectations. We have to respect the legitimate expectations of the investor. So, for example, if they've made an assurance that they won't do something and then they turn around and reverse themselves, the host state, that this could violate the treaty. Well, but there's authority suggesting, I think this is very well reasoned, that an investor cannot legitimately expect the host state to violate its pre-existing international obligations. So it can't rely on any undertaking that the host state might make to do so. And then in addition, the newer generations of treaties consistently, or I don't want to say consistently, but increasingly are containing language that's intended to broaden and confirm the host state's regulatory authority, exceptions, provisions, carve-outs, reservations, where they essentially say for certain types of acts undertaken in the public interest, meeting certain criteria, even if this would otherwise violate a treaty standard, the host state can't be liable for those. For example, in some of the more recent U.S. treaties, carve out whole categories of environmental and cultural regulations which are reserved and can't give rise to liability under an investment treaty. I think this is a good practice. Canada's treaties increasingly have similar language. And then there's also the fact, and again, this is something I know from my personal experience representing investors, that even if the host state violates a treaty standard and there's no language in the treaty exempting them from liability, such as a reservation or carve-out, then the investor may still be deterred from bringing the claim. This often happens. The investor knows that if they bring a claim against the government, then this is going to be seriously undermining their relationship, especially in a highly regulated industry. They don't, unless it's a last-ditch resort, very often investors don't want to bring those claims. And for example, in Venezuela and Bolivia, when these nationalizations occurred, the vast majority of foreign oil companies essentially rolled over and agreed to sign contracts, giving up their majority stakes and essentially acquiescing to what the government was offering, and I think in large part because they felt, hey, I can still make some money and I don't want to be kicked out of this country. So I think that they may not all treaties may strike an optimal balance, but I think in general, investment treaties do have a certain stabilizing effect. They give investors an opportunity to bring claims in some sort of extreme circumstances when there's been discrimination, when there's been an expropriation without compensation, but they also still give the host state considerable regulatory leeway. So let's contrast these investor-state dynamics with those with local stakeholders. I would argue that in this context, investors have a very distinct advantage over the local stakeholders, and this is from several factors. So disproportionate financial resources. We're talking about major multinational oil companies who have vast resources at their disposal compared to local communities, which typically have very limited resources. They have superior access to information. So let's say, for example, they're negotiating for some sort of impact benefits agreement or some other sort of arrangement that would be providing access to some resources. They obviously know more about the project or in a better sense to evaluate any potential adverse impacts than the local stakeholders would be. And also, whatever inherent advantage investors have, that is typically compounded, or in some cases compounded, by what I would refer to as an effective alliance with the host state, where the host state, because of an overlapping interest, they actually want that investment to be carried out. And so in terms of when I say an alliance, so there's the overlapping financial interest, because the government's getting revenues of one sort or another from this operation. There may be powerful local constituencies that want the investment to take place. There's also the risk of corruption, especially in developing countries where the investor may pay off certain officials to get certain deals. So then In either case, there's a pattern one can see in different instances around the world where the investor concludes a contract with the host state, gets access to resources, they get some sort of permit or authorization, and there are also maybe rights that they have under domestic law, which are then enforceable under the host state's legal mechanisms. And then we also sometimes see a disinclination on the part of the host state to enforce whatever obligations that the investor may owe toward local stakeholders, either directly or indirectly, whether we're talking about environmental laws or labor laws or something else. So if we were to consider the oil sands as one possible, whether or not it fits this pattern, we see, I think that certainly from what I understand, the Alberta government is largely dependent on oil sands related revenue, that it's sort of financial condition fluctuates depending on how things are going in the oil industry. I'm certainly not aware of any corruption. I think we see that more in developing countries. A lot of the reports you see do talk about a certain degree of coziness between government and industry in terms of personnel going from one to the other and back and forth and so on. But I'm certainly not aware of any actual corruption. But we certainly do see investors securing rights, leases to develop oil sands resources. And oftentimes, according to the reports I've seen, there are allegations that these leases are granted without prior consultation, or at least adequate consultation with First Nations, which do have treaty rights in these areas for hunting and fishing. And I know I'm not an expert on Canadian law. I know there are arguments that, in terms of that the government doesn't necessarily need to consult in some circumstances, but at least according to the allegations, there are concerns about governmental authorizations being granted without adequate or any prior consultation, let alone consent, notwithstanding adverse impacts. And then in terms of host state failure to enforce obligations, there are also allegations that the Alberta government doesn't always enforce environmental restrictions that may be on the books in terms of, for example, pollution controls and so on. And so there's those allegations. So what I argue is that because of these dynamics, what we end up with is a distinct power asymmetry in favor of the investor as against local stakeholders, which creates a risk of abuse. So in terms of impact of investment treaties, we looked at the impact on investor-state relations. Essentially there's really no impact. They don't deal at all with this power asymmetry. They're targeted at the asymmetry between states and investors. They don't say anything about relations with local stakeholders. There's no human rights obligations imposed on investors. There's no equivalent mechanism for local stakeholders to enforce their rights under international law as against the investor. It's just not dealt with at all. So in terms of, to the extent that one wanted to target this, what I'm arguing is this this asymmetry. There are various potential solutions that one could employ. I wanted to highlight. So of course, maybe the best place to start would just be with domestic institutions. Trying to reform environmental agencies so that they're more active in enforcing the laws and so on. But my concern is that the factors that inhibit countries from regulating multinational enterprises are really just exceptionally difficult to deal with. I mean, how are you going to wean governments off their dependence, at least in the short term, on oil revenues or other investment projects? To the extent there's corruption in developing countries, that's endemic despite decades of efforts to try to weed it out at the international level. There's, to the extent one were to try to reform host state courts and make them more receptive to claims. I think whenever you got claims being brought against foreign investors, that creates all sort of foreign relations complications. When there have been cases like this, very often the investor will claim it's being unfairly persecuted and try to invoke, run to its home state and get them to intervene and put pressure and so on. It's just going to be really messy. In terms of, so really what I think ideally we'd have some sort of international option where local stakeholders under some circumstances could have access to an international forum to enforce their human rights. Unfortunately, human rights courts that have been set up to date lack jurisdiction over private actors. That's not an option at all. And so one of the things that I've argued in my papers that should be considered as an alternative would be arbitration. This is coincidentally, this happens to be the form of arbitration chosen for investors to bring their claims against states to enforce their rights under international law. And I think it has much to offer in terms of the fact that it's neutral. It's not going to create those foreign relations frictions that we talked about. So in terms of how this could be done, they could enact. Arbitration is a creature of contract. It has to be the investor has to agree to arbitrate. But I think there are different ways that they could be incentivized to arbitrate, either through domestic legislation or through investment treaties. I'm going to explain how investment treaties could be employed essentially as corporate social responsibility devices. Instead of just devices to give rights and protections to investors, they could be tempered with measures to try to encourage corporate social responsibility. So essentially they would articulate certain core human rights obligations and require each of the parties, the countries to the treaty, to take measures to enforce them. Specifically, they could make any governmental benefits conditional on an agreement by the investor to arbitrate with local stakeholders should they believe that their human rights have been violated. In terms of what rights would be violated, just sort of the most important, universally accepted or widely accepted human rights, rights for the security of the person, forced labor, child labor, some say the right to collective bargaining, non-discrimination on the basis of race or ethnicity or religion and so on. And then also I would put in this category indigenous rights as articulated in the United Nations Declaration on the Rights of Indigenous Peoples, declaration of the General Assembly in 2007, very overwhelmingly endorsed by the international community. Only 4 countries voted against it: Canada, the United States, New Zealand, and Australia. All of those countries have since reversed course and endorsed it. So we now have it just overwhelmingly embraced by the international community. And what this document does is it articulates certain rights that indigenous peoples have, being recognized as being particularly vulnerable to the impacts of development. And these would include things like, some of these are applicable to the private sector, not just states, and the ones applicable to the private sector, I would argue, are things like the obligation to conserve the environment of indigenous peoples, to protect their cultural sites, to respect labor laws, and the right to be free from exposure to hazardous chemicals and so on. I would argue that, I know from representing investors, they don't want to go into an investment without knowing in advance what they're expected to do and what their risk exposure is. And I think UNDRIP doesn't go nearly far enough in terms of giving clarity, so that, I would think that you'd need to provide more clarity to investors so they know, for example, what do I have to do to respect the local environment and so on. And so I would suggest the treaty incorporate by reference certain existing international standards, or at least use those as a starting point that, dealing with these issues. So for example, there's the Akwe-Khan guidelines on impact assessments for development projects on indigenous lands, promulgated by the Secretariat of the Convention on Biological Diversity. There's World Bank performance standards for indigenous peoples, and there are also labor standards that have been devised by NGOs, and so these could potentially be incorporated by reference to provide that additional clarity. I would argue that you have to not just target direct violations, but also complicity with the host state if there's aiding and abetting that takes place. And then to just, I'm going to wrap up here in a few minutes, but to talk about, okay, well, how would this work with regard to the oil sands if we were to implement these ideas? Canadian, what they call FIPAs, the Foreign Investment Promotion and Protection Act, although I don't know how, somehow they lose the extra P when they do this, but so FIPAs and free trade agreements, they would require that any covered investors, when they're coming in as a condition to any governmental benefits, such as leases, or before they're going to be covered and get the benefits of the treaty, they need to enter into a written agreement in which they promise to respect UNDRIP and other whatever human rights are incorporated into the instrument, and then arbitrate with First Nations or whatever other stakeholders. And you'd have to define who had standing, regarding any alleged violations. If the government, they wouldn't be able to point to the fact, well, the government authorized me to do this investment, and the government, there was a case saying that we didn't pollute in the water. Those decisions wouldn't be binding under my proposal, because each of the governments would be promising the other to uphold these would be obligations of the government to each other to uphold these and enforce these human rights. And there's wide authority saying a decision by a government regarding its own respect for international obligations is not binding on an international tribunal. They would be able to, however, I would argue there should be a defense if you have used due diligence to try to comply with whatever standards are articulated in the treaty. And then, they could obtain monetary damages and injunctive relief. I guess in closing, I would just acknowledge that I'm under no illusions about the fact that this is, I think, exceptionally difficult sell for governments. I think that governments are going to be reluctant to do this for a number of reasons, and obviously multinational enterprises would lobby very, very hard against them. I do, though, think that there's some value simply by pointing out the fact that investment treaties could be drafted to do this, because I think we see then that effectively a conscious choice is being made by governments not to do it. That they're choosing instead to focus exclusively on the rights and protections of the investor, and not to provide a comparable mechanism to local stakeholders. And I think pointing that out has a certain effect. And then also, I think that in the long run, whether they do it via investment treaties or through some other medium, I think something has to be done. I think something. There are a number of factors that could contribute to something actually being done in terms of regulating multinational enterprises and providing a mechanism for enforcing it. Just some factors I would highlight. I think there are serious security and foreign relations implications of violation of the rights of local stakeholders. And I think it makes Canada look bad if that happens. I think it makes the United States look bad if one of their companies comes to the oil sand and were to violate human rights. It can, in Nigeria, we've seen a civil war result which has obviously security implications. I think as we're seeing with better modes of communication and media coverage, we have things that used to happen out in the rainforest nobody knew about are now being known and publicized. We see increasing sophistication and solidarity of those who are advocating for human rights. Just take, for example, in Canada, the controversy over the Enbridge pipeline. I've seen that the First Nations haven't just been protesting locally; they've also been cooperating with what we would call Native American tribes in the United States, who are staging solidarity protests and so on. And then also, as these CSR standards I talked about, the Aquacan guidelines and the performance standards, as these are increasingly refined and come to be used, I think so that it becomes actually more feasible for companies to carry out with clear guidelines what they're supposed to do for the protection of local stakeholders without unduly inhibiting development. I think companies are less likely to see these in the future as a threat and more willing to take on some sort of binding enforceable obligations. Well, that's all I have. Thank you very much.